Hi, everyone. I'm Joseph,
Hello,
and
I'm
this is Gabby.
Gabby.
And today we are going to just stick to our normal path where we're going to talk about a news. And in this case, it's going to be the request for evidence and notice of intent to deny being essentially canceled. It's going to go back to the original intent of the law, according to what this new memo is saying, where officers can just directly deny the case without giving you an opportunity to submit more evidence. We're going to go in depth and talk about it. This could be a good thing if it is done right. If it is done right, and that's a big if. So we're going to be talking about the entire history of it. What does it mean for practitioners who are in the immigration space? If you are an agent, if you are designated Department of Justice official, if you are an official representative, if you're an attorney, if you're working on these cases, what does that mean? We're going to dive in deep. We're going to talk about our internal company policy as well. But this is a big deal. This is huge. And then we're going to talk about success story. And in this case, we're going to today's success story is going to be another E2 case, but it's a double E2 case, as in it's there's one company with two E2 employees, and there's really only two E2 employees, and the company went from like $2 million in revenue down to 500,000. Profit is extremely low, but we still got it approved. We're going to talk about how, and we're going to talk about the methods, and just to help out people, right? Because if right now E2 extensions are getting really hard, we're seeing a lot of denials across the board. So this approval means a lot, and we want to talk about that in depth, right? And again, as always, Gabby and I were here to answer any of your questions if we can, right? We don't do a lot of different case types, but if you guys have a question, we'll do our best to try to answer you and your specific situation. And today we have John, who's helping answer a lot of these questions. I mean, at least to ask the question. So whatever questions you ask, he's gonna ask it, and then we're here to answer. Okay, ready?
Ready? Yeah, it's so much.
So much. The first thing we want to talk about is the new request for evidence and notice of intent to deny memo that just came out. It is right here. It issued on August 5th, 2026. The long and short of it is that they're saying we're going back to the original policy of this law based on how Congress intended. An officer, when they're reviewing a case, can either approve it or deny it, or give request for evidence or notice of intent to deny. And that is clearly stated. In the original law, there was never a mandatory requirement where an officer have to give a request for evidence or a notice of intent to deny and give you an opportunity to rebut their findings in the application. But in the past 30, 40 years, and this goes back all the way to INS, Immigration National Services, right? All the way back then, and then it became USCIS, and then several separate memos came out to kind of talk about what are the internal policies where an officer have to give a request for evidence, when should they do it, how should it be read, when is it too much, when is it too little. And over the past 20, 30 years, there's a lot of back and forth regarding request for evidence and notice of intent to deny, and now a new memo that just landed August 5th is saying, well, you know what? Officers don't have to do any of that anymore. If an officer looks at the case and the applicant didn't provide the basic requirements, they could just deny the case. They don't have to issue the request for evidence. They don't have to issue the notice of intent to deny. That is what we want to talk about today and the implications of that. There's so much I want to talk about. Anything you want to talk about?
There's so many things that come to mind right now, only because I have been to this USCIS interviews as an interpreter in the past. So, when they are conducting an interview, they are trying to be as quick as possible. So there's very little room to explain, something that will be complicated. And that's when these RFEs become very important, right? That you're giving the client a little bit more room to explain their case, to maybe even, provide information that was not discussed during the interview, and then the cases get approved. But now, if the officer just assumes that their idea is, what is actually happening, when that's not the reality, then the client is out of luck. Now the case is going to be denied, then you have to refile. And hopefully when they issue the denial notices, it's clearly explained why the case has been denied. So if you have to refile, then you can actually argument on those weak points. But it's just thinking about it, it's just so hard to like see what's gonna happen in the future with these like complicated cases. People that have easy cases usually file on their own, try to do it on their own, but when it's complex, that's why law offices come into place. People hire an attorney, they want to try to do it the right way. Now, if we're not given the opportunity to clarify something that's either misunderstood or even not part of the original filing, then how do we deal with that?
One of the things that we're seeing in this request for evidence, and this has been going back and forth, right? During Trump's first administration, he wanted to do this. And just like everything else that we've been seeing, from the travel bans, from the tariffs, from everything, he's doing exactly what he did in the first term, but now he's doing it a lot better. And so, and more succinct, and with a bigger legal team that kind of defends it. And he has a much more support, both in Congress and in the Supreme Court and everywhere. And so, he's been wanting to do this. Now, both Obama and Biden, they also issued these similar memos. The attitude towards requests for evidence and notice of intent to deny is this, right? When people apply to be an immigrant, they already paid all this money, they already prepared everything. It's complicated, it's a lot. The officers should look at what they have provided, and if there's room to get approved, they should issue the request for evidence to try to help the client get approved.
Mm-hmm.
There were times when USCIS was talking about treating applicants as customers. When they address people, it should be customers with an intent to try to approve. That's a very benefit mentality agency. People are applying for a benefit, they're trying to become a visa holder, a green card holder, they're paying lots of money to the immigration system, right? Thousands of dollars, when the adjudication time sometimes is 20 minutes, even though the actual time, it's years, but the actual manpower time could just be minutes. They're paying lots of money. If the officer doesn't feel like the case is quite up to par, look at it and issue a request for evidence to try to get more documents to get it approved. That's a benefit kind of mentality. Now, the Trump first term and Trump now, during this memo with this USCIS team, is saying, no, we're a vetting agency. People are trying to take benefits from the US government, take taxpayer money, clogging up our system. So if they did not meet the basic burden of proof of submitting the basic requirements, then we could just deny it. We don't even have to give a request for evidence. Giving a request for evidence is a privilege, not a right. And so that's what is happening. We saw it before, and we're seeing it now. Now, a lot of their rationale, when you read it, it's saying there's a lot of people who are clogging up the system because they're filing frivolous applications that don't even meet the basic requirements, and they're trying to get a benefit out of it, right? Because just by merely filing a adjustment of status application, you get a receipt number, you can use it as a shield against ICE, you can do various different things. But if USCIS is able just to quickly deny a case because they say you didn't meet the basic requirement, then people will no longer be doing this. Because if they issue a request for evidence, also in the past, when you're given a request for evidence, you're given sometimes 3 months, the maximum amount of time. Well, now basically people have spent the money and now they bought this extra time and they're trying to cancel that, right? Now, how many people are doing this? Have USCIS directly issue denials even without this memo? Sure, we see USCIS deny things all the time without a request for evidence, without a notice of intent to deny. You're missing a signature. Boom, the case gets denied. Your application fee was off. We're overpaying. Boom, the case is denied because contractors are adjudicating these, right? By scanning things in. You mail to the wrong place, even though it's a USCIS office, boom, denied. Missing some basic information, boom, denied. We see this with H-1B all the time. So even without this memo, does USCIS already deny cases? USCIS have always given the grace of giving people the maximum amount of time, 3 months with request for evidence, and sometimes 1 month with notice of intent to denies. Now they're saying, we don't have to give that. We could give you 1 week if we want to. We could give you 2 weeks to respond if we want to, right? Now, what's really interesting is we have a lot of meetings with USCIS officers, right? Previously, a lot of our interns, our staff now works at USCIS. We understand the internal policies, and USCIS officers love their job, hopefully. They don't want to get fired. They don't want to do anything wrong. If they're receiving a big application and they don't know if they should approve it or deny it, to be safe, they issue the request for evidence, right? Give us more things. We don't know if it's enough. Give us more. That's the safe thing to do. And so now this rule coming out gives them the power to directly deny or approve a case and gives them the authority to do that, and also internal policy change, right? A lot of people don't know this. In the past, just like any government work, when you're given a task to do, adjudicate this case, well, you're tracked with your time. What are you doing? Are you approving it? Are you denying it? Are you issuing requests for evidence? Are you researching back into the State Department? You're given a certain amount of time to process a certain case, and whatever action you do, you're given a point to show that you're working, right? Very government work. That was in the past. Then, can't remember exactly when, a couple years ago, only approvals and denials are tracked. Request for evidence, sorry, that's no longer tracked. Notice of intent to deny, sorry, that's no longer tracked. You're not rewarded for doing that. That's just, that's something you're doing. But they're still tracking what you're doing, but you're not given like a point. It's not, rewarded in that sense, right? Because there's no final outcome. So now USCIS is trying to push USCIS officers, when they're adjudicating cases, to just directly approve or deny. Here is the problem with this memo. When the public reads this, they might think, yes, of course, when you file an application, you should do it correct the first time. Why waste the government's time to try to search and give you the benefit of the doubt and give you a request for evidence opportunity? You're supposed to provide 4 things. You didn't provide 4 things. You should be denied. Here's the problem with that. In so many cases, it is very discretionary. You don't know what exactly the government wants. If you look at any single case category, whether we're talking about H-1B, whether we're talking about L-1A, we're talking about EB-1A, we're talking about change of status, we're talking about marriage applications, there's so many factors. There's so many things to look at. What is sufficient and what is not? And when a case is filed, sometimes it could take a year and a half or 2 years. And what if during that year and a half, the standards have changed? We could talk about O1 standards completely changing this year. We could talk about H-1B standards completely changing within an administration. So what is that bottom basic red line, right? And this is addressing practitioners, people who are in our firm, people who are working with us, people, and again, just basic advice to anybody who's practicing in the immigration field. This could be to your advantage, meaning we can now hold the government to this standard. You are incentivized to directly approve and deny. You are incentivized not to give requests for evidence and not to give notice of intent to deny. You are that is wasting of government resources. That is wasting of government funding. You are supposed to approve or deny based on the law. Great. Now, what is the law? Here's the O1 requirements. Here's the O1 regulation. Here's the examples that you give. Here's the prior case law. These are the cases that have gotten approved in the past. These are the evidence that you're looking for. Here's the direct language. We have provided more than sufficient amount. It's beyond the preponderance of the evidence. You ought to approve it here now. No request for evidence, just directly approve it, right? So now we can try to hold the government to their standard, right? Oh, you're not supposed to issue requests for evidence. Great, good for you, good for us, good for everyone. It's a win-win situation. The client paid for premium processing, the client paid for the application fee. They have provided more than enough based on everything that we've seen. So please directly approve the case now. That is somehow the one way that we could try to make this case better. Are there a lot of questions, John?
A few.
Okay, why don't you go ahead and ask, and then we'll dive into the public charge. We'll dive into the request for evidence more.
Okay, so 2 concerns from green card holders. One of them asked, they got their green card through I-485 change of status, but before they got the I-485 approval, he was out of status, but then they got the approval. So now that if they're going to travel, are they going to have any issues?
Yeah. let me start by saying, let me repeat the question first. Somebody, the people who are asking already got the green card, but before they got the green card, they have some maybe unlawful presence issues, some overstay issues. Now, if they're traveling, coming back in, will Customs give them a hard time, right? Well, and let me define a hard time. If you mean the officer might ask you 5 more questions at the primary inspection, that might happen. Standards have changed. Ever since last year, CBP's requirement to inspect people entering and exiting have went from, being lenient to being as strict as possible, arguably, right, based on the executive memos. So that's what they're supposed to do. So if in the past 5-10 years, you've enjoyed coming into the country, leaving and coming into the country, and you get asked only 3 questions, where did you go? Where are you going? Where do you live? Okay, well, that was on the lenient standard. Now, because it is heightened, you're getting asked 10 questions. That is normal. Not to be alarmed. We are, quote unquote, in a state of multiple wars with the world. Expect that when you're going through law enforcement. Now, if you get pulled into secondary and you have to wait an hour and then you're questioned some more by another officer digging into your past, again, that's nothing to be super alarmed by. A lot of people have to go through that. And if you answer appropriately, it still should be fine. Now, if you're talking about legally, should they go back, reopen your case, will CBP officer confiscate your green card and make you go to secondary deferred inspection, make you go into immigration court, call ICE? The chance of that is still extremely small based on what you just said, based on the unlawful presence, any sort of overstay issues, because your green card has already been adjudicated. If, however, after you got your green card, you committed criminal activity, you've been convicted, if in the past there was drug-related offenses, then, of course, CBP has the authority to deem you inadmissible, right? But I think the most important thing is if what you're concerned about happened before you got your green card, it's been adjudicated, it's been approved, CBP doesn't really want to re-look at those issues. That they have too many other things to focus on.
And for the same person, is there any difference between international and domestic travel?
In your situation, as a green card holder traveling in and out of the country, domestic travel, you're significantly more safe. The news that you've been seeing last week from the New York Times about ICE detaining people in domestic airports, those apply to people with I-94s that are expired. So not green card holders.
Okay, so another green card holder of 22 years, but they have a fare evasion fine from 2010 and paid before going to judge. But in upcoming I-90 or foreign travel, is that going to affect the case?
I don't know what okay, so somebody who's renewing their green card, they had a fine with a judge, they paid it. Will the I-90 be approved? Will the green card renewal be approved? And will the travel be okay? It completely depends on what the case is about, right? Some convictions where the fine is very severe and Customs will see it and they might question and they might deem you inadmissible, right? The Supreme Court case is a prime example of that. There was a 3rd-degree trademark infringement, right? Okay, and then now they lost their green card. They were deemed inadmissible. They couldn't come into the country legally, right? So it depends on what the court case is about. If it's a civil fine, a parking ticket, that's not the best way to find out for sure. Take your judgment, right? Whatever conviction you have, you could plug it into ChatGPT, you could plug it into Gemini and say, is this an inadmissibility? And if the answer is a clear no, print that out and show it to the customs officer and you should be fine. Right? Now, if you want a second opinion from an immigration attorney, that's fine, right? Book consultation, but generally that should be the right.
Okay, so we have a few questions on timing and waiting. So one is, hi, my perm was approved a month ago, but my lawyers haven't processed my I-140.
Right.
They said they're waiting for the employers to complete their side of paperwork.
Right.
Is this normal?
Yes. And it ranges from company to company, right? Some employers are really on top of it. They've already prepared months and months beforehand because obviously the perm took an extremely long time to go through, right? So the employer was already ready. They already have everything ready. And so the moment permit approved, you could file the next day. But some company policy, well, once the permit approved, then we go on to the next step. It could take another 3 months, right? You need people to sign off on it. So not to scare you, but what if the company is deciding to lay you off? There's no point to kind of continue with the I-140 because that's a huge application fee again for the company. So there's a lot of things to consider. It is totally internal within each company.
Okay, and one person asked, they received their I-130 marriage on September 3rd, 2024, but still didn't hear back anything. What can they do?
I wonder if it was a concurrent filing. Is that what they are asking? So
Yeah.
a petition has been approved and they haven't heard back on the rest of the case?
A receipt notice for I-130.
Oh, they haven't received a decision on the I-130.
Yeah.
So first thing to do, contact USCIS to ask if there is anything they can do to push the case, or if not, file the service request online as well, so that then you can remind them you're still waiting for a decision. But 2024, 2026, 2 years, that's a little bit long. The longest that we've waited for an I-130 approval is about 1.5 years recently. So if it's already hitting the 2-year mark, September 2024, then I would say definitely contact USCIS and ask them about it.
And it also depends on if the petitioner, right, is a green card holder or a U.S. citizen. But yeah, those are things you could totally do on your own without having to hire anybody. And the next step, if it's still way beyond processing time, is you contact your senator and congressman. They have a form for you to fill out. You fill everything out. They represent you. Then they'll send an email into USCIS to double check for you, right? So all things you could do on your own.
Okay, and a question. Submitted my application to I-130 and I-485 in July 2024. I've been waiting for my green card interview. I'm a Canadian citizen who is in a same-sex marriage to a U.S. citizen.
Oh my
My birthplace is in Thailand. Is that a problem? A notice of interview was scheduled in November 2025. Another notice was sent one day later to cancel the interview with no reason given. No updates so far.
I wouldn't read too much into it.
Mhm.
Okay, and let me explain why. We see USCIS the past year and even this year send out a lot of interview schedules and then canceling it. So it's not just you. Why is that? Maybe they're updating their system so that interview notices are automatically sent out, and then suddenly the officer is reviewing the case. They go, oh, I don't want to do this interview, so cancel it, or I'm not ready for it, we're rescheduling. So don't read too much into it. We've seen good cases get scheduled and canceled. We've seen bad cases get scheduled, and yeah, so don't worry about it. Don't look in too much into it. DOMA case, same-sex marriage case, it used to be a red flag when it first came out, like 10 years ago, right? 10 plus years ago, 12 years ago. Now it's very straightforward. So I wouldn't worry about Thailand thing. I wouldn't worry about you being a Canadian citizen or it's a same-sex marriage. It's still very normal application case. It's been a long time, sure. It's slightly on the longer end. We've seen some married to U.S. citizen cases get scheduled within 6 months, 3 months. So in this case, it's a little bit longer, but it is not completely out of the ordinary. Just live your best life, keep on preparing things, and if you do get an interview, which likely you will be, then you're able to go in and really present yourself, right? Now, they could be sending somebody to, your workplace or your house to double check if the marriage is real, right? That's something that's happening. But I wouldn't read too much into the whole schedule and not schedule. But your case is a little bit on the longer side.
And hopefully the work permit was already approved. So
Yeah.
at least they can work. If not, check on the work permit
Right.
until you get the interview.
Most of the time, your work permit gets approved, 6 months, 9 months, right?
In the past, 6 to 9 months. Now it's more 10 to 12 months.
10 to 12 months for work permit and
Yeah,
travel
for work
permit.
permit.
And some more questions on time.
Yeah.
Waiting. My F2A case was filed in July 2023. My spouse is from Guyana.
Uh-huh.
How long more I gotta wait to get approved?
F2A was like
Well,
2+
F2A
years,
is
right?
yeah, that's permanent resident applying for the spouse.
Yeah.
So that would be, yeah, like for the I-130 to be approved about 2.5 years,
Yeah.
because the priority date may not even be current, depending, you know.
So if you don't know what a priority date is, a lot of people don't know. Double check the priority date, and you're under the column of worldwide. And so look at F2A and
The very first
the
call.
very first column. Your case is not likely going to be even touched, looked at, or approved until the priority date is near your time, right? And so when you file the case, that's your priority date. So look at it, and when it's getting closer, you know, and I, in my opinion, I think October 1st, you'll see a big jump because of the 75 country pause that Trump has instituted. And so it will jump forward. And so maybe, you know, maybe your case will be adjudicated on October or November. I mean, just a real estimate.
Okay, my husband got approved for his green card after being detained. He didn't get his green card yet. So how long does it normally take to get the green card?
If your case is approved by immigration court, right, or by USCIS, or I guess the consulate or CBP, right, whichever agency approves it, the next step is they send it to the card processing center, and then usually within a month or 2 months, the green card should be mailed to you. But that's assuming the case got approved, right? And we're talking about the 485 adjustment of status or the consulate approval, right?
I submitted an N600 for a child, but got RFE for physical presence. So he's wondering if that's right.
Yep, all the time.
Yeah,
Yep.
that's normal. That's pretty normal. Just submit the documentation to prove.
Now, that's the thing, right? The N600 is a perfect example, right? We see N600 RFEs all the time because the regulation doesn't spell out exactly how many documents is needed to prove physical presence, to prove physical custody of the child, to prove parental relationship, to give some examples. So is 2 documents sufficient? Is 20 documents sufficient, right? And so in these type of applications, when you're applying for a citizenship for your child, how much is enough, right? And what do we compare it to? Do we compare it to a driver's license? Do we compare it to a mortgage? Do we, in every other American civic life, when you provide, I mean, we all have these examples. You go to DMV, you go to different places, you provide 1 or 2 documents, photo ID, bills, maybe that's sufficient. But suddenly in immigration, even 20 documents is not sufficient. So this new memo allowing officers to look at a case and say, oh, you didn't meet the bare minimum, so I'm going to deny you. Now, if whoever is applying for N600 literally just filled out a form and provided 5 pieces of evidence and submitted a payment and say, I want my citizenship, and the officer looks at it and say, nah, I'm going to deny, maybe they could do that. But in our experience, even people who are doing the cases on their own, who prepared everything, they come to our office, ask us to review it, a lot of these conscientious individuals, when they go through everything, they still provide like 15, 20 things, especially ChatGPT these days. When you're asking what should I provide, they give you a long list and then people do provide it. So under what scenario is USCIS really going to be denying a lot of these basic applications? You know who's going to be harmed? It's going to be people who are largely illiterate, people who are, you know, just doing it on their own. They're paying thousands and thousands of dollars, filling everything out, you know, children doing it on behalf of parents or whatever, and then they get a few things wrong. They one of the criteria, they only provided 1 document as opposed to maybe 5, and the officer just denies the case, and they are the ones who are truly going to suffer, and that just sucks, you know?
So I am on employment-based adjustment of status, no H-1B, API 94 expired, no violations in the past. Any risk of traveling domestically? If ICE detains me, do they send back home or release or ask us to appear in court?
If you are in adjustment of status in an employment-based case, and your I-94 is already expired, and I don't know how that situation can happen, but if you're traveling domestically and your I-94 is expired, ICE can detain you. They've said it. They have the authority to. Now, you're at question, what do they do immediately? Partially, that depends on how you came into the country. If you came in as a visa waiver, and depending on where you get arrested, they could directly send you back. You have no rights to a bond. You have no rights to an immigration judge. They could directly send you back if your home country is willing to take you. They could detain you for 6 months to a year or even longer, waiting for that, bond. That could happen also. That happened to the Irish guy because he came in on a visa waiver, right? So it depends on how you came into the country, how your I-94 expired, where you are in the country when they detained you. That is all relevant. It's crazy to think about that, right? Now, is that happening all around the country? We are not seeing that. If you have a valid application that extended, I think it's still very rare for ICE to be detaining people at domestic airlines and airports. But do they have the right? Yes.
For biometrics, how long after biometrics are you seeing it take for the Santa Ana field office to schedule interview, or in general at the moment for the cases you have?
What type of case for the interview?
Probably marriage.
Doesn't say, maybe marriage based.
Yeah, because
so usually about 9 to 10 months after the biometrics are completed is when the interviews are coming for marriage based. And for 100 is a little bit different. For 100, I would say probably 3 months to 6 months after the biometrics are completed.
Yeah.
Unless there's criminal records, then they have to look into, like incidents with the police. But yeah, usually those are the time frames.
Okay, so I-485 for a citizen parent got RFE for missing I-693 and promptly sent the response. USCIS acknowledged receiving the response, but what to expect next?
So you would still usually go back to the original processing time, right? Even though there is an RFE, there is a small delay depending how quickly you respond to the RFE, but I would say they still go based off of the current processing times for the 485 based on the field office. So you continue to count, for example, for parent of a U.S. citizen is usually 12 months to get a response. Sometimes it's 9 months. But I would say if you file in January of this year, you probably won't hear back until January of next year, even with the RFE. And that was just medical exam, so it's not anything crazy.
And this is another point where we really want to emphasize. Providing a medical is mandatory in adjustment of status applications. A lot of times, people can't get it on time. We've seen it happen too often for whatever reason. People couldn't get it on time. In the past, you file to show you've tried, and yet you will provide it during the interview. Sometimes it works. We've definitely seen it work in the past. Now with this memo, they might say, nope, it has to be, it could be denied immediately because you didn't meet the bare minimum requirement of submitting the medical exam. Now, this is relatively crazy because in the past, the medical exam has to be valid within, 6 months period. But, during COVID and right after, sometimes an application, as you're seeing from these these questions, sometimes an application could take 1.5 years to 2 years. So your medical, by the time the officer actually looks at it, is already far expired. And in the past, you have to go get a second one. We've seen some cases where, during the green card application, you're supposed to do 1 medical, but they end up doing 3 or 4 medicals because expired again. You have to do it, but, government is just taking so long, right? Yet now they're saying, well, you didn't even provide a medical exam, and so we can directly deny your case. So we're going to see a lot of motion to reopen happen because of this memo. If the officers are beginning to deny cases without meeting the bare minimum requirement on the certain things, when a lot of times it's their own fault, right? For example, adjustment application, it's going to take 2.5 years before you get an interview, or just going to take 1 year. The medical is only valid for 6 months. Well, then why do I provide it now? Why don't I provide it at the interview? Doesn't that make sense, right? And if at the interview, I don't provide it, then sure, deny. But why need to do it in the beginning when it's invalid already, right? So we're going to see this become a big litigated case. Now, there's going to be a lot of online filing push too, right? Part of this is you could provide things online. So maybe before the request for evidence, if you submit it online, maybe, they instantaneously get it and they won't deny a case based on request for evidence. But we're going to have to see, right? The government is using AI, the government is pushing for online filing, and the government is pushing to directly deny cases if it doesn't meet a certain threshold. We're going to have to see what that threshold is. If everything works out as they intend, if there's good officers who are adjudicating good cases and they see frivolous filings, they directly deny, and it makes things a lot more efficient and makes a lot of people stop filing frivolous applications, and they do a better job in preparing everything, making it much more easier for the officer, and that might save USCIS. That might be a good thing. But if the officers are not trained, if they have a strong prejudice, if they just start denying cases left and right because, a signature is off or this and that. I mean, we've seen officers deny cases because the handwriting is too neat. It looked too much like DocuSign. It was too neat. And so they denied the case. But it was clearly a wet signature, and we had to do an appeal for that, right? So if we see officers abuse their power, it's going to be a bad situation. But if we have still good officers, they have proper training, this policy might be good if it dissuades a small number of applications. So we really have to see.
Okay, so submitted I-751 waiver RFE for 19 months and still waiting for decision. How long does it take?
So usually 751 waivers take about 48 months to be processed. It could be a little bit longer if there is fraud investigation for the marriage, but after you submit an RFE, again, you count from the time when you filed your case up to the 48 months, right? So if you got an RFE 6 months after filing your case, you still have to wait another 3.5 years to get a response. So it just depends on when your case was received and how long you have been waiting in total.
And if you've had your green card for a total of 5 years, you could file an N-400 to try to push them to adjudicate your 751 waiver faster.
Okay, I was recommended B1B2 for music recordings. I got 214B and also lost my ESTA. If I find a job now, how long should I wait before applying again?
So if you got denied by 214B because you have immigrant intent, you're at a consulate, you can't come in with a B1B2 visa, you lost your ESTA privilege. Your question is, when can you reapply for a visa if you get a work authorization, right? And so if somebody wants to sponsor you, and that depends, right? If you're doing an O1 application case, once USCIS approves everything, then you go to the consulate, then they interview you, and then if it gets approved, then you could come into the US, right? So the timing, you could, if you have the approval from USCIS, you can directly go back to the consulate. Now, if you're saying, I don't want to do the O1, I don't want to do H1B, I don't want to do E2, I don't want to do anything with a formal application, I just want to walk into the consulate and say, I want to work in the US, I want to do this thing, can I do it? You really have to persuade the officer that you are doing it under B1 or B2 category, and you have no immigrant intent, and you're not harming the US, you're not stealing US jobs, so you can look into that, right? But if you're doing anything with music, probably look into the O1, right? O1B specifically, where you just have to prove you're distinguished, right? And so we did a couple of success stories on this on our YouTube channel. Feel free to check it out.
Yeah, can my wife sponsor me if she had no prior income but now earns above the required income?
Okay, I think this is a public charge question. Can your wife sponsor you to try to get a green card? Will the government approve your green card based on her income? Because if she's too poor, she doesn't have enough earning capacity, and you don't have enough earning capacity, then the government will think you and your family will become a debt to society, and they will deny it based on public charge. That's the context of this question, right? Public charge rules have changed significantly, especially it's going to go into play this September, right? And what we recommend is don't look at just one factor. So your income, she's earning capacity, her W-2 income, her tax return, her her pay stubs is sufficient now, but that's only one thing that the government is now taking into consideration. look at multiple channels, right? Assets, joint sponsor, career growth, promotion, health, your assets, your income, your future. Look at everything combined and prepare a case that way. Don't just rely on, oh, I have a couple pay stubs that meets the requirement now. I should be okay. 2, 3, 4 years ago, sure, that would have been the case. Very few cases get denied based on public charge because that's such a slap in the face, right? You waited years and years, you paid thousands of dollars, and the government says, nope, no green card for you because you're too poor. Like, that is just not America, right? But now it is. Now that is a thing, right? According to Trump, like, apparently, if you don't have earning capacity, you don't have good moral character, even though he had multiple bankruptcies in his lifetime, right?
I was out of status for a few years, but now I have U.S. citizenship. I'm planning to travel to my country, Nepal. Is it safe right now?
So this is right? Just like the green card question. If things that happened before you became a citizen, that's not something that the customs is
should look at.
Yeah, they're not that concerned with it. That's not their focus. They're trying to catch criminals. Immigration violation prior to your adjustment or to your citizenship is not the main thing, unless it's a drug offense, unless it's national security.
I have a friend, her son came in with F1 visa, but last year she filed EB-5. She transferred her son from private school to public school. Her case still processing I-526. Is her son in have public charge?
Because of the public school.
Good question. That's a very interesting question. So let's really talk about it in depth, okay? Somebody came in as an international student. You're on F1 international status. You can go to a private school, but you file now EB-5 program. So you invested probably $800,000 or $1 million into a particular project. And then you file an adjustment of status application, and now the case is pending. If you filed it last year, it's probably pending for 1.5 to 2 years, so you probably didn't get the green card yet. But you might have already gotten your travel permit and your work authorization for the kid, and they have authorized stay, so they can stay in the United States. During this period, are you eligible to go to public school, and are you using government benefits? And how long did you go to school for? And does 245K cover it? All that is very interesting. You are going to public school, you're receiving public benefits, you're not paying tuition anymore. Normally, that would not look good. That looks really bad, actually. However, you are an EB-5 investor, and that you are investing over $800,000 or $1 million, and so you probably have sufficient income to prove you're not a public charge. So it's going to be up to the officer, right? So there's no clear-cut answer. For sure it's not. For sure it's okay. Prior to this September public charge rule, almost everybody will say most likely that's not going to be an issue. But now with this new rule in place, your 526 hasn't been adjudicated yet. It's only when your 526 gets approved, then your 45 gets adjudicated, and then at your 45 adjudication, it's already past the September time, public charge rule is already in place. Are they in danger, right? Should they have stayed with a private school? Probably would have been a lot better, right? But there's so many things you don't know. And that's what I mean by immigration policies are changing by the month. And so what is that baseline standard? And did you provide enough, right? What if at the time, 526 approval, thank you for your money, thank you for investing in our project, we approve your 526. However, 45, we're going to deny your green card because we don't think you're wealthy enough. Wouldn't that be crazy, right?
Crazy.
The change in regulations and plans.
Yeah.
And without a request for evidence also, right? Like, because in this new, I don't have to give you a request for evidence. I see you're going to public school. You're using government benefits. We're just going to deny you. Wow, what a crazy.
Crazy.
Yep.
Just even think about it.
Yep. Now, are officers going to do that? I hope not. I don't think so. I think this is a very power move, giving the officers much more power and much more discretion, so that if they want to deny a case really fast, if they only want to give a 1 week request for evidence notice, they can do that. Are they going to do that for across the board for everyone? Most likely not, especially in the next 6 months. I think typical USCIS fashion, they issue a memo and then they spend 6 months to learn how to use it. So I don't think it's going to happen immediately, but in the next 3, 4, 5 years, are we going to see a trend to modify? And it depends on what the next president is going to do. Are they going to rescind it, right? So again, 2005, the request for evidence memo came out to really clarify what is a request for evidence, what is a notice to deny. Obama, I think around 2018, issued a really clear statement. It shouldn't be a fishing expedition. It should be very clear on what request for evidence is supposed to do. You're not supposed to try to get too much information. You should try to approve it. And then Trump came in and says, no, we want to go back on that. We want to change everything. They might have gotten the dates wrong. And then 2021, Biden is saying, no, let's go back to the request for evidence. Let's make it fair. We want to approve people. And then now 2026. So this memo came out, right? So every 3 to 5 years, a big change with regarding to this request for evidence. And it depends on just what your philosophy is, right? USCIS, are we a benefit agency? Are we a vetting agency? Are we trying to help people get approved? Or are we trying to deny as much as possible? Are we gonna, and most people are in the gray area, right? Most cases are in the gray area. Like, is your marriage real or not real? Well, how do you determine feelings? Is 5 evidence enough or is 10 evidence enough, right? That's so much of immigration, right? So much of it. Are you extraordinary or are you not extraordinary? What evidence are you looking at? Everything is so discretionary. Your investment amount for an E2 application, is 200,000 enough or is 20,000 enough, right? Everything is so subjective.
Yeah, and through the years, we have seen RFEs with a 2-week window for response.
Yeah.
But those are usually, for example, like if they are requesting a new copy of the birth certificate. Suddenly, the system does not show a copy of the petitioner's birth certificate. You can quickly go to the recorder's office, you pay it, you get for it the same day, you submit it tomorrow.
Right.
So, those are okay. But when you're talking about RFE for like a co-sponsored, your co-sponsor doesn't qualify, or suddenly, the guideline change or the form, whatever the situation may be, it takes a little bit more time to go back and try to get a co-sponsor. So if you give a 2-week window, it's kind of like you're setting up people to fail. That's not doable.
Yeah.
So now it's like, okay, if you're giving 2-week windows or 1-week window,
Yeah.
like, it takes 3 days for the mail to get to that person.
Yeah.
You're giving them 7 days, like they have 4 days to act on it and mail it back.
Yeah.
That's why I think it's important to see to the option to file online. We learned yesterday that even medical exams now can be opened and submitted with the 485 application for adjustment of status.
Yeah.
So in the past, we could not open the envelopes. Now it's like, open the envelope, give it to the officer, just bring the envelope to the interview, which is supposed to make things faster. But I think now the way to go is to e-file.
Right.
These short windows, don't allow us to mail it out, for the post office to send it back to the USCIS office. So everything is changing and we just have to catch up with it.
Yeah.
Here's a repeated comment, but I'm not sure if it's a question. My husband is in AP since his interview in October 2025, had 2 illegal entries, but he was minor.
AP, advance parole?
Yeah, advance parole. And so will the case get approved? It's still pending. Getting the advance parole doesn't mean this case is, on track to get approved. A lot of people think that, I successfully did my biometric, I successfully got my combo card. That's just part of the process, right? Now, we do know certain really bad cases, they want to deny very quickly, so they don't even want to issue those. But for most cases, those things can get approved first, but ultimately it's still looking at it. Now, if there's multiple reentries, that is something you really want to sit down with an immigration attorney, really look at your case, because that could be denied and you could need a waiver. You might have to go through immigration court. There's a lot more complications there.
U.S. citizen, I applied I-130 for my stepson who's under 21 on September 2025. What is the timeline right now?
About 12 months. So maybe in another few weeks, next month, they'll hear something back.
Yeah.
Okay. I have a pending asylum, and I have applied on March 7, 2023, but my B2 visa expired March 6, 2023, and now I have EB3 case, and I think it's safer than asylum. But my question is, can I apply for I-485?
No. So we don't do asylum cases. But if you're in the United States and you're trying to transfer from your asylum case to an employment category case, unfortunately, the employment category, even with 245K, that law only covers 180 days. And so it's almost impossible to go from asylum to EB3. If it's to US citizen marriage, potentially they could do that because of 245A, but employment type cases, you can't do 245A for the 45. You could only do 245K, and that's only 180 days. You don't know what these words mean, these numbers mean. ChatGPT can quickly explain it to you, but that's why 45 is not possible. Oh, louder? Oh, okay, cool. So it's let me repeat. Going from asylum to adjustment of status 45 is most likely not doable because you can't use the 245A provision, and that is usually tied with marrying a US citizen. 245K is allowed for most employment-based cases, but that only covers 180 days, and that your asylum case is probably far longer than that. So we haven't seen an asylum to employment case for that purpose. Now, can you leave the country and go to the consulate and get a green card after the priority date is current? Possibly, but you're subject to the discretion of the consulate, right?
Okay. What advice can you give to my friend whose girlfriend plans to enter the US on B1B2 visa? He plans to marry his girlfriend in the US and petition for her, but they want a consular processing, not adjustment status.
Great, right? That's wonderful. The new memos that came out are all attacking people who want to do adjustment status in the US. If it's merely to get married, to file a petition, and you're going to do consular processing, it's not that concerning. But if the officer sees, oh, you're dating a US citizen, you're gonna get married to a US citizen, I think you're just gonna adjust status. So that is something you want to think through and talk to your friend about, and if and see how you want to talk to the officer. Again, it's legal to come in to get married, but you really have to convince the officer you are definitely leaving. You're definitely not doing adjustment status. And one of the ways to convince them, you have the return non-refundable ticket, you have a clear wedding destination and everything, you have a great job abroad, you have a clear intent of why you're gonna go abroad. Maybe the US citizen can explain everything as well. I mean, it needs to be super crystal clear. And hopefully you're only gonna come in for 1 week. And you could tell the officer, you can only allow me to enter for 1 week, and that's totally okay, right? That is probably the typical, recommendation we give to people who do consultations.
What are the chances for my adjustment of status to be approved as a K1 visa entry, but through a new spouse?
Oh, you did a case recently on that.
So fiancé visa that was petitioned by one person, but then end up getting married to another US citizen and doing adjustment.
Right. What do we have to do again?
Mine was a little bit different. It was just marrying after the 90-day mark.
Okay.
That they got married after the 90-day mark. So we had to file an I-130 with the adjustment of status because it was the same person, but they had gotten married after, like a day after the 90-day mark.
So they have to file
we had to file an I-130 along with the adjustment of status because the I-129F only allows 90 days to get married.
Right.
That was my case. But this one is saying, like, for example, one person petitioned for the K1.
Yeah.
They came in, but now marry a different U.S. citizen.
Yeah.
Right? So, I mean, that's
if I remember correctly, obviously still I-130 and still 45.
Mm-hmm.
Right? Because
it's legal.
It's a legal entry, right?
Mm-hmm.
But I forget the rest of the details.
Yeah.
There is some nuance because you're a K1 visa holder that entered the country. And especially you definitely need to prove why that first relationship, almost like a fraudulent marriage, They will suspect you got the I-129F approved and the consulate approval and CBP approval to enter the country, but you didn't get married to this person and you're technically supposed to leave, right? And was that all real or not real? And if they determine that that was fraudulent, now you have a fraudulent case and they have to do a waiver. But there's something else about it that I don't quite remember. Yeah. Yeah.
Yeah.
I applied adjustment of status and did biometrics. How long does it take to get work authorization?
About 9 to 10 months.
I got granted my asylum case and I was waiting for almost 1 year. How long can I wait to apply for green card?
We don't do asylum cases, so we don't have the logistics and the timeline for that. But plenty of asylum attorneys, would be able to tell you the timeline.
My dad has 4 years with U visa, has no criminal record, pays taxes. What steps should he take next?
We don't really do U visa. Sorry. Plenty of U visa attorneys would be able to advise better on that.
I-130 approved, I-485 still pending. Last update was canceled RFE, but RFE never issued. Is it going to be approved soon?
Wouldn't read too much into it. USCIS is updating their system. They sometimes send interview notices without intending to do that. Sometimes they see something is missing, they automatically send out RFE notices, but then they cancel it. I wouldn't read too much into that. Keep on waiting. Maybe they wanted to write something, they found something else they want to write about, and they cancel it. There's just too many possibilities. Don't read too much into it. Keep on waiting. Keep on checking. You don't want to miss an important notice.
Yeah, there was a system update, I want to say 2 weeks ago, where even some cases that were got an alert saying that they were approved, but that was a mistake. There was another message that came in the next morning saying, oh, there was an update in our system. Some messages for approval were mistakenly sent for some application. So please disregard. Your case is still pending.
Yeah.
So it's probably very similar to what you're saying. The RFE was issued, but it was never mailed because there was probably a system thing. So yeah, a lot of things like that are happening, and same with the interviews, right? Like the interviews that get canceled is all the system errors. So
yeah.
My I-130 case just got closed after a year. Can I have it reopened again? Sent I-485 after it closed.
Closed does not sound good. Because closed might mean they're going to give you a notice of intent to appear to go to immigration court. That's usually what we see. Approval is great. Denial, maybe you can challenge and fight and you can just see why they do it. Closed usually means not our jurisdiction. We don't have to deal with this case. We're going to pass the buck to somebody else. And who does USCIS usually pass the buck to? Immigration court. And so if you filed the adjustment of status, but your I-130 is closed, it might mean they're getting ready to deport the individual. And so even if you file the 45, that 45 could be closed. So that's extremely unfortunate, but we'll see, right? Maybe it's not, but I'm just sharing what we typically see.
Newsweek put out an article that the current administration plans to have another change in naturalization testing, where parts of it will be with a third party. Have you picked up on something about it?
No, I have not picked up on that.
They talked about it probably about 2-3 years ago, but it never went into effect now, like using iPads and going to like a contractor in the USCIS offices for everything to be like just on an iPad to do the testing. But that was a seminar like 2 to 3 years ago. But recently they haven't really mentioned anything about contractors.
I can totally imagine that though, because the N400 is a unique application compared to everything else. There's so many things that the officer is supposed to review. And so if this goes into effect, what I think it will mean is that it will be now essentially 2 interviews, or a test and then an interview. USCIS officers, especially the citizenship interview officers, part of the things that they hate doing across the board is they hate doing a citizenship interview and then having to deny somebody because they couldn't name the president. They couldn't get July 4th down. They couldn't write legibly.
Mhm.
to an 80-year-old grandmother who has a hard time hearing,
Mhm.
or denying them because they couldn't say how many chairs are in the room, right? They hate that part. And no other part of immigration adjudication in the United States requires that level of like this test. And that is something contractors are so easily able to do. And you could put all the blame on them. If they deny you because of that, well, then sue that contractor agency. Don't sue USCIS, right? So I could totally imagine USCIS bifurcating this process, charge an additional fee for it, outsource it to a contractor, and now you do your biometrics. Now you have to go to, do this iPad questionnaire interview with a third-party agency. And then once that gets approved, then you do the actual citizenship interview. And now that interview, that 30 minutes, that 40 minutes, that hour interview can purely be dedicated to your physical presence, good moral character, what USCIS officers are actually trained to do. But we'll see. Today's success story is about an E2 investor treaty case. Now, what's special about it is that it was an employee. So the employer, the owner of the business, got an E2. The employee, now he wants to hire somebody else to also join the company as an E2. They're both from Taiwan. So the employer started a business in Arizona back in 2020, 2021. They got the E2 approval. He's here. The employee came, I think, in 2022, 2023. Now the two of them are running this business, and the business is not doing well. In fact, the business went from revenue of $2 million down to last year only about $500,000. Profits dwindled even down to $30,000. $500,000 in revenue, $30,000 in profit for one employee is like already extremely hard. For two employees, for two E2s, it is nearly impossible from what we've all seen, right? It's just such a low revenue amount, and it's not like they have a whole bunch of employees, and that's why profit is very little. If they have like 10, 5, 10 employees and they have a lot of costs, all right, sure, they're still stimulating the economy in some other ways. But if revenue itself is only like 500,000 and most of it is just parts and goods, and there's only two employees on payroll, which is them, that's not looking good. That's really looking quite bad, actually. We filed the case and it got approved. How? Here is what Andy's team did to focus on this E2 case in Arizona. First of all, it was a tech company. It's focusing on memory chips. They're from Taiwan. Taiwan is one of top 3 memory chip producing countries in the world. Taiwan sends about top 5 countries in the world that send people over to the US to do E2 applications, right? So like Japan's number 1 by a huge margin, but like Germany, I think France is up there. I think United Kingdom's up there, but a couple big countries, Canada, Mexico, right? Thousands and thousands of people. But then right after that, it's like Taiwan. It's a treaty trader with the US, and that many people come to the US with an E2 application, and they are extending their E2. Now, with such low revenue and profit, how are they able to get it? Well, we focus a lot on the future, right? Because AI is booming, it takes time to build it out. AI big boom in Arizona with all the investment, but all that investment is going to real estate, is going to construction. The actual purchasing of the memory chips hasn't actually taken off. It was big in 2022, 2023. That's why they had the $2 million revenue, but things have slowed. Business have slowed. But don't deny case just because of that. They have a big plan to continue. They've already invested $200,000 into it. They made so much revenue. They've spent so much. Even though revenue is low, even though profit is low, don't give up on us just because of 1 year. It's a trending downward trajectory, but AI takes time to build out. So we built out that business plan. We showed that the applicant went to Arizona University, is in the industry, and it is in the industry for an extremely long time. We show the trends of AI going up in the future. We show that AI boom, but it's in phases. Prepared that, filed it, case got approved. And so that's just one of the things that we want to share. Even if revenue is low and profit is low, and there's so many people using the resources, it's still tied to the bigger picture of the US economy, right? Write it in a way that the officer can fully understand. Why Arizona? Because all the AI investment is going towards Arizona with all the data centers. Why are they there? Because a lot of it is from the Taiwan investments. It was profitable before, but it's slowing down, but it's phases, right? So they are doing their best. This is everything they provided. Please approve the case. We didn't get a request for evidence. The case was automatically approved. We have 2 extra years. Now they really have 2 years to kind of prove themselves. E2 is one of those case categories that as time goes on, it gets harder and harder. A lot of people think, oh, it should get easier and easier. That's not the case, because in the beginning, you have a business plan. You're doing a pitch. Now, when you do the extension 2 years later, you have to prove what did you do. If the first extension you tried, but you didn't do that well with your tax return, okay, we'll give you another 2 years. We'll give you another 2 years. But it's getting harder and harder because, well, you've already had so much time. And if you still can't pick yourself up, then you probably are not going to succeed and they deny you. So we've seen, the third E2 extensions, the fourth E2 extensions, or even the second E2 extensions get denied because, well, you have all this time. And so unlike other things that things get easier and easier, these visa categories actually get harder and harder. And again, I don't know if there's information online, but some people say it gets easier and easier. I just don't think that's the case. And so we just want to warn everybody, if your case doesn't look good, you really have to work hard during the extension phase. Okay, so that's the E2 success story.
Congrats, Andy.
Yeah, congrats, Andy. Good job. We'll see you guys next week, right? And then I think we're going to pause for a week before we come back. But thank you guys. See ya. Take care. Bye.